Get started?
Mhm.
All right. So, congratulations to us. We made it through Article 6. So, I think I have us in starting Article 7, and we made it most of the way through 701 last time, right?
Right.
But I think Cody had sent around a memo on charging orders, which I think would probably make sense to discuss at the outset. Cody, does that make sense to you?
I think so, because I think it affects 701.
Yeah, exactly.
Oh,
So, I mean, I know how I feel about this, but Cody, do you want to walk people through who may not have had a chance to do a detailed read of your memo, walk through essentially what your argument did, well, what the people whose arguments you cite are, and then what your recommendations are based on that?
Yeah, sure. So, and I'm coming at this primarily from the creditor's standpoint, the judgment creditor. And it's, so it's not from the perspective of, a bank, a bank deal, voluntary stuff. This is where we get, a judgment, whether I'm representing a bank or a hard money lender or somebody else gets a judgment against an LLC member. And it's often the case, for example, that there are two members of the LLC. It's the debtor and wife, for example, or the debtor and his buddy, or something like that. So, they just don't make any distributions. Oftentimes, they've got many LLCs, and the one LLC maybe owns the real estate, and that's about it. And so it doesn't do anything, right? They're just sort of asset shielding in a sense, and it can be very expensive to bring a veil piercing claim and all of that. And it's uncertain whether you even win that. You don't even usually have the information you would need to allege that from the outset. And I personally find charging orders very frustrating. I know that there are tax implications for a creditor who then, if you didn't have a charge order, you might just foreclose on that interest in the LLC, for example, but you can't do that in any event. And with ROLCA, with charging orders being the exclusive remedy, I was looking at, what does the commentary say about this? And looking at that Oregon Supreme Court decision in Law versus Zemp. And, that decision does talk about the ability to use ancillary orders to try to give teeth to what is otherwise a bare naked charging order. And those ancillary orders might allow, for example, theoretically additional discovery or restrictions or impositions upon the LLC. And theoretically, there may be more bite to the bark of a charging order, but I'm not sure that can always get you where you want to go as a creditor, which is, actual money in hand rather than just having some judgment against someone who, they're often, it's not like these people are truly penurious and their one asset is this LLC. They're usually living very nice lifestyles. They're just hiding the money. So you look at the Professor Pomeroy's article, and I think it's an accurate statement of the general view of the effectiveness of a charging order among both lawyers and courts and commentators, and including, the lawyers for the people who are creating these LLCs to shield their assets, which the prevailing view being that charging orders are oftentimes worthless, and that creditors often don't even bother with them. And then Professor Pomeroy, who had written his article in 2014, points out that, but there's one useful thing that you can do, which is, if you foreclose, then you have the ability not to obtain, but to seek a court-ordered dissolution of the LLC if it's being used for oppressive purposes, as I think is not always the case, but often enough is the case in these kinds of situations where you'd be seeking this. You sit there with your charging order, maybe you've got it for a year or 2 years, and you get nothing from it because they make no distributions. This ability upon foreclosure, and we discussed that last time, that foreclosure doesn't really get the creditor hardly anything. And in fact, it weakens your position because it makes you subject to the operating agreement, No longer do you necessarily you lose your informational rights that you have as the holder of a charging order if you foreclose. So what's the benefit? There really is hardly any benefit. Under the prior law, which was the law under the last version of the 1996 version of the Uniform Limited Liability Company Act, and which was still part of ROLCA all the way up through the whole process to the very end, when they excised it, was this ability of a creditor who foreclosed on a charging order to seek judicial dissolution in cases of oppression. And that is, that oppression is described in current, ROLCA section 701A4C. And so my proposal is to reinstate this provision that existed under the old ULLCA, that existed under all the drafts of ROLCA until the very end, and therefore give some level of teeth to and something to be gained by foreclosing a charging order. So that's my proposal, and I recognize by doing that there'd be a few other, some tweaks to other provisions that would be associated with that, but there's no point in discussing those tweaks if the group doesn't support this change to ROLCA. So that's my pitch, basically.
Yeah, Cody, this is an expansion, right, of where we are with current Oregon law, right?
I'm trying to remember what current Oregon
I
law
can
says.
address that if you want.
Yeah, go ahead.
Because this is a sort of a live issue. So the way that Oregon's LLC statute was written did not previously provide that charging orders were an exclusive remedy for pursuing creditors' rights against a member who owed money as a judgment debtor.
Mm-hmm.
And for a long time, people would from time to time exercise these rights to foreclose the member's interest, the judgment debtor member's interests. And it's not common for people to want to do that, because when you take that interest, you also then own whatever tax hairballs come with it.
Mm-hmm.
And many creditors don't know enough about what risk they're taking to be willing to entertain that risk. But I've seen it done to great effect. I know lawyers in Eugene who did this probably more routinely than I ever did. Saw it happen in a case. I've never done it. As long as I've represented creditors, I've never foreclosed on an LLC membership interest, because I've never had a creditor that was willing to take the blind tax risk. But I do know it was possible. It was not possible in many states, because the way that the statute was written and adopted in many states, it did not provide for an option to do that. And our language on that was somewhat non-standard, which allowed us to do that in Oregon, but not in other places. I personally think there's a lot of trade-offs to this. As a creditor's lawyer, which is what I primarily do a lot of, it'd be lovely to have this tool in the toolbox, even if it was something that I would sparingly use. But I can also see, in terms of the pick your partner principle, why that is really problematic for the other people who are members of an LLC. Because if you foreclose and then own that membership interest and can force the LLC to do something about it, then it is impairing the ability of the other partners to run the business the way they would have wanted to run it. And I'm sympathetic to the case Cody's talking about, because I have seen this. I've litigated it. I've got a case pending in the Oregon Court of Appeals right now, where it's exactly the kind of conduct you don't want to see from LLC members, where they're moving the interests around and they're not making distributions, and they're playing hide the ball with the express purpose of defrauding their creditors and hindering and delaying their ability to collect their debt by not making distributions, by running stuff through other entities that they should be running through this entity, and just engaging in bad conduct. So the problem is real. that Cody's identified. It is a problem, but I don't know how much foreclosure ability really solves that problem, and whether or not it's worth exposing the vast majority of LLCs to the risk of this rule just because of the few that are very bad. And while personally I lean toward I would like to have this ability, I think it's a real issue worthy of discussion whether this should be the rule for all LLCs. I mean, I wish there was a way you could limit the proposed rule to cases where, you know, you do just have the bad conduct. And I'm curious when we look at section 7 and it talks about oppressive conduct, exactly what oppressive really means in that context. Does it mean I'm trying to keep money away from my creditors? Or does it mean oppressive as to the interests of the other LLC members? Because, you know, sometimes those people will all be aligned in interest in keeping things away from creditors, and sometimes they won't. So, and I'm sorry, this is sort of very stream of conscious.
I think that
But
I think it,
Cody, I don't think Teresa was done, Cody.
Oh, sorry.
no, that's okay. I was sort of winding out and trying to figure out where I was going with it. I guess that it's an important problem that I think we ought to spend some real time talking about. But much as I like this solution, even I might not be totally persuaded it's the right thing to do here, if we can't figure out how to limit it just to people who are trying to hinder their creditors.
And just on that one point, that last point you mentioned, it does read that it's oppressive and was or is or will be directly harmful to the applicant, which in this case would be, if it's the creditor who's the applicant, it would be oppressive to the applicant, to the creditor,
Okay.
not the other members.
And it isn't oppression. I mean, certainly in the corporate world, majority oppressing the minority and lawsuits over that. There's, I think, a lot of common law on that. I mean, I would say that even though a lot more of it is probably on the corporate side, the LLC side, there's a pretty good understanding in the law what it constitutes oppression. It's just litigation on it over the years, particularly in the corporate side, and it takes a lot of different forms. It's not
I
just.
agree.
So
Well,
the commentary says that as well, actually.
That
So-
sort of raises the question, because let's assume the case that Cody was talking about, which is you have, you know, a 2-person LLC, it's a guy and his buddy, they own a piece of real estate, only one of them is a judgment debtor. And let's assume that the judgment debtor really doesn't want to pay his creditor. And so he's going to vote every time to not make any distributions so that there's no funds that will come out of that LLC to the judgment debtor. But the other guy in the LLC could be one of 2 flavors. He could be complicit, and he could be helping his co-member avoid his creditors and say, sure, you know, I'm happy not to take any money out of this LLC as long as it helps you screw that creditor over there. Or he could be the opposite. He could be the member that says, I don't think we should consider that at all when we are making distributions from this LLC. I think our number one concern ought to be what's good for this business. And if it's good for the business to make a distribution, we will. And if it's not good for the business to make a distribution, we won't. So in that circumstance, let's assume then that the judgment creditor isn't getting paid, wants to foreclose the interest, and then comes in and wants to force a distribution out of this company. While it might be fair to enforce that against Mr. Complicit, it's probably not fair to enforce that against Mr. Straight Up. And how do you distinguish that if you're to create this right? And I think that's really what the struggle is here.
Yeah.
Because in either case, Mr. Bad Judgment Debtor's a bad guy. There's no question that he's a bad guy as to judgment creditor.
I think that in my experience, it far more common scenario is where the buddy is complicit. This may not be the only LLC that they're both involved in, and they've probably got a whole bunch of them, and they are, they're scratching each other's backs in what they're doing. And I think that if you really have the the angel and a partner who really is just trying to do the right thing, but can't overcome the veto of their bad business partner, I feel like then that good partner is going to be seeking a dissolution anyway, because these people aren't actually doing business anymore. Now they're just, now they're in their own internal struggle. And I just think that that's a pretty rare fact pattern where you really have that angel partner who's burdened with the sort of the devious partner.
And in my cases, in your cases, I agree that's probably true. But I'm a bankruptcy lawyer and you're a litigator, and I wonder if we see a skewed group of the universe.
I do a lot of bankruptcy too, and yeah.
So I know Michael had some thoughts that he wanted to share on this one.
Yeah.
I guess the first question is, isn't there some other remedies for Teresa? I mean, you talked about it, the few that are very bad. And Cody, I mean, basically people using LLCs to hide assets. Isn't there remedies, other remedies in other places like the Fraudulent Conveyance Act, for example, if you're truly transferring assets to avoid creditors, it seems like the creditors have some remedies there to chase those assets wherever they may be transferred to, or to whomever they may be transferred to.
But wouldn't that apply, Michael, in this case to the membership interest? In other words, you have a charging order against an individual member and against their membership interest. And if the LLC transfers assets, does that implicate the Fraudulent Transfer Act? Because the creditor's not transferring the assets, the LLC is transferring the assets.
Well, if the LLC, you're talking about someone that transfers assets to an LLC and then the LLC transfers those assets further?
Talking about, you get a charging order against an individual creditor, so you get a charging order against the membership interest, and then to avoid that, they transfer the assets out of the LLC to some different entity. They just move the assets around. So at that level, I don't think the fraudulent transfer would apply. It would apply if you, for example, transferred the membership interest, because it applies to the creditor's assets, and the LLC's assets are not the creditor's assets.
Well, I think if there was a fraudulent conveyance into the LLC and another conveyance to avoid creditors, I would think the fraudulent conveyance could potentially implicate the second transfer.
So are you trying to get to the initial or the contribution, that the transfer of the capital contribution into the LLC would be a fraudulent transfer?
Well, I think I'd like the litigators to weigh in here in terms of how in some of the scenarios that are being postulated here, the few that are very bad. And I don't deny that there are a small minority of those that use LLCs for nefarious reasons. The vast majority of people that form an Oregon LLC do not do it for that reason. So what I'm trying to get to is for the few that are very bad, aren't there some other remedies in our current law to deal with those folks?
Well, and so I think it's not very often the case where a judgment debtor will transfer property into their LLC against which a charging order has been entered, and then have that LLC transfer it out. There you would have a fraudulent transfer action maybe, but primarily because of the transfer from the debtor to their LLC. If, as is I think far more often the case, the LLC has certain real estate or other assets that it's already holding on to at the time that you get your judgment. And if that LLC decides to then convey those assets away, I don't know that you have a UFTA claim, because that's property of the LLC. That's not your judgment debtor's property. They haven't transferred their, I mean, that's the shield of the LLC.
Yeah, but the act does talk about both current and future creditors. I mean, and it has a 4-year statute.
Right, but that would be a creditor of the LLC, not a creditor of the.
Well, I'm not so sure. If you have a member of an LLC that is a debtor, or even a potential future debtor and has transferred assets into the LLC in order to avoid their outside creditors. And that's what we're focusing on here. I think it does potentially implicate the fraudulent conveyance statute.
Right. But I'm just saying, I think it's the more common factual scenario that you don't have a debtor who or a potential debtor who transfers things to an LLC to defraud creditors. I think usually the placement of property in the LLC is done legitimately. And the problem is then that once that relationship with the creditor goes south, in particular, once they get that charging order, then the debtor just ossifies that LLC, and it basically kind of just does nothing. And even if you can get the bank records of the LLC, you won't see a lot of activity, or maybe you just see the LLC sort of piling up cash and not doing anything with it. And if you go and get the judgment debtor's personal bank accounts through a judgment debtor exam, things like that, I think oftentimes what you'll find is that then they don't really have any personal assets. I mean, that's part of the plan from the start, is to not have assets in their own name. And they've got some other LLC, which is an operating entity. And then they're probably abusing that LLC and buying groceries through that LLC's account, but you can't see those account statements. You don't have any access to that.
Except that that's a piercing the veil argument. That's another.
Right. But then you don't know that they are, you assume it, but you don't have that evidence that, hey, they're using that LLC to run all these improper, lifestyle payments through, because you can't get those bank statements. You would have to be sort of on belief, on hope, and maybe that's enough to get past Rule 17. And it may well be, but I don't know. That can be tougher to actually have some evidence that this, or any one of you don't know which of their LLCs. They often have many they're using to live their lifestyle through.
If you had a charging order against an LLC and you thought it was being abused, for example, looking at 7.01, was it AC, what you mentioned before, the oppression claim, does that give you the ability to maybe get through discovery the bank statements for the LLC?
If you have foreclosed, then you don't get the bank statements anymore under ROLCA. As the holder of the charging order, you can ask the court to appoint a receiver to obtain that information. That was something we had discussed when we were discussing how the charging order works. And my memory was that we decided to leave it be with the receiver at being able to get that information. But so before you foreclose, you would have access to the LLC's bank statements. And I think that in the mine run of these kinds of cases, where you do have this nefarious conduct going on, you're going to find that there isn't a lot of activity in that LLC bank account. They've kind of let it be dormant, I think, is usually what happens.
Yeah, I think Cody's right that there are challenges to doing this, but I also think that Michael is right that there are other causes of action you can pursue. The problem is that they're just very cumbersome and very expensive and very difficult, because you can obtain information about whether the LLC is paying for the judgment debtor's groceries, for example, through a judgment debtor exam process, because you can ask in a judgment debtor exam is not limited to just taking an exam of the judgment debtor. It's anybody who has information about a judgment debtor's assets, income, or whatever. And so you could find a way to get to it. The problem is that it is very cumbersome and expensive. And it is difficult to pierce the corporate veil. It's one of the easiest things to say and one of the hardest things there is to prove. But there are those remedies.
So I'm curious about what James and Cliff have to say about this as well. To totally call both of you out.
So I am sympathetic to the scenario that Cody describes, and certainly in my 5 years of litigating during the last recession, I encountered similar circumstances and spent time in debtor exams that led to nothing. It's a real problem. I don't think this is the right solution. I think allowing a creditor to interrupt any LLC with any number of members and interfere with the relationships that have been set up it's too broad, it's too much. And I mean, frankly, if this were what we adopted, I think my advice to pretty much anyone forming an LLC, and frankly, anyone who already has an Oregon LLC, my advice would be, if you think there's any risk that one of your partners may someday become insolvent, let's form or convert to Delaware, because that's safe.
James,
Yeah.
I'm in a similar place that I at least feel compelled to advise clients to go elsewhere beyond Oregon. And I guess also, I mean, that leads to a question: are we aware of any other state in the United States that has this form of remedy in its statute, in its LLC statute?
Michael, before we go there, can I get Cliff's reaction to the general proposal?
Yeah.
Yeah, it scares me just because, to James' point, the fact that any member that you enter into an LLC with, to the extent they have one of these orders, and a creditor can come and essentially grab that LLC and take its actions. I think it's just overreaching and would put Oregon at a significant disadvantage with respect to your state in terms of risk of the state of formation.
So I guess one question I have for the two of you before we move on to Michael's question, would your feeling about this change if it only applied to wholly owned or controlled LLCs? So the situation that Cody's talking about, where you have the guy and maybe his wife who are owning an LLC and he's the judgment debtor. And so the two of them, there's no third parties involved.
I think
Valerie,
Cody's
I think
already
it
got the
already
remedy he
does.
wants. Yeah, he's already got that remedy for a single member LLC. He can foreclose and get the full membership interest. And I think that's appropriate.
Yeah.
And that is, frankly, that is beyond what some of the more aggressive states would do, like Nevada and Wyoming. I think they will respect a single member LLC to the edges of the earth. And I don't think that's appropriate. So I think Rilke strikes the right.
And to answer Michael's question, this provision, like I mentioned, was part of the 1996 Act. And so it was adopted in several states. Do I know exactly how many states right now have this power still these many years later? I don't know. I don't think very many would have that still, if any. I don't know though.
Yeah. And it was a real question, not a rhetorical question.
Yeah.
It'd be interesting to see, when you go with the 96 ULCA version, whether states have picked that up and whether they've since changed.
Mm-hmm. One question I have is, reading the room, and maybe I'm misreading it, but it seems like this proposal of mine is not majority supported. But also it seems like there's majority concern for the issue, the problem identified. And I'm wondering if anybody has any alternative solutions that they feel would protect the non-debtor partner, but at the same time provide a more effective mechanism than either the UFTA or the judgment debtor exam to resolving this problem.
Well, so Cody, let me tell you how I feel about this, because I think it is an interesting problem, right? And it's something that we sometimes see when I'm talking to our family law lawyers as well, where you'll have a membership interest in LLC as part of the marital assets, and how do you collect on that? But my concern that it creates risk for the non-debtor members that they didn't sign up for necessarily. And my bigger concern, though, is that this is a big policy change for the state of Oregon. I think that part of the mandate of this committee is to highlight areas where we think that maybe policy changes may be appropriate, but then to have discussions with other interested parties that may want to weigh in on those, you know, and that may have the ability to propose a better policies position than we can. And here, you know, I think this is would be a great project for the debtor creditor section. Teresa's smiling. She's like, because they have folks on both sides of the argument there, right? And so to the extent that it's not working, you know, to the extent that this is a tool that is determined to be necessary, then I think that would be a more appropriate group to address this maybe than our group. Teresa, what do you have thoughts about that? Other than it's bad to give work to bar committees that you don't belong to.
Oh, I'm definitely involved with the debtor creditor section. No question about that.
I know you are. I was just saying my suggestion that they take it on might be seen as more than appropriate.
Yeah, you know, in terms of a policy change, I think that what Cody is proposing is consistent with what we had before Law versus Zemp. And now it is not consistent with what Law versus Zemp said, because Law versus Zemp really tried to pull back on what a judgment creditor could do in order to pursue its rights against an LLC. So it's hard to say that it interferes with a long-standing policy, because the longer-standing policy was to allow something like this. That said, I mean, I do think it somewhat changes the rule in Law versus Zemp, and we would have to bring that out, I think, because that is a change in the law. It's something that would be different. And it's just really hard to figure out how to write a skunk rule, right? This is the rules that applies to people who are jerks and not doing the right thing, but it doesn't apply to people who are, you know, good people and following all the rules. Because skunks always try to make it look like they're following the rules, and good people trip over and end up doing something skunk-like by accident. And so I don't know that there is a great solution to this or a middle ground, and I wish there were. I mean, one thing I like about ROLCA is it does allow for the execution on the single member LLC, because that is one line that I do think you can draw. And it does go farther, I think, than states like Wyoming and Nevada would go. And I think it's the right place for Oregon to go. I mean, we talked about that in Section 5, and I think it should stay the way that is in ROLCA. But I'm not seeing a really good way to write that skunk rule, and I wish I could.
Yeah.
Can I just offer two insights? One, I think that the skunk rule, Teresa, is the court's equitable discretion, which is essentially what OLCA does, right? It says where it's equitable to do so, the court may order the dissolution of the LLC. And then the question becomes, do you trust courts to make the right call? And I'm generally a skeptic of courts, but I think that's the relevant question. The second point I'll make is that our partnership statute seems to have in it the rule that Cody's asking to be incorporated into the LLC statute. I'm looking at ORS 67290. It essentially has, right on.
Mosin, you muted yourself.
I know, I was using the space bar. Now I'm just unmuted so I can look at the other window. It says on application by a transferee of a partner's transferable interest, a judicial determination that is equitable to wind up. So essentially that section allows for a transferee to seek judicial dissolution where it's equitable to do so. So to the extent it would be a policy change for our state, it's already baked into our partnership statute, which I recognize is a different entity, but LLCs are based on many of the principles of partnership law. I generally come out in the same direction that Michael and James and Cliff have articulated, that it just will put our state in a competitive disadvantage. So I don't know what gain there would be to add it, because people just form elsewhere. But I also recognize the problem.
But what's interesting is the partnership by definition is at least two partners to be a partnership. Whereas right now, the equitable remedy in ROLCA is only on a single member LLC. So it seems like the partnership rule is actually a little broader, like you could apply it to a multi-member LLC.
That's what Mosin's saying, yeah.
Okay.
Yeah, I mean, I will say though that the Partnership Act is the next one that Commissioner Shetterly would like us to address. So, David, you've been very quiet.
I'm in the Michael category as well. So
Aurelia, do you have anything you want to add?
I mean, I guess I kind of favor Cody's proposal. I think the backstop is, as Mosen points out, the courts. You have to show oppression, or you have to show illegal or fraudulent conduct to get that dissolution. And that seems to me to be perhaps a tough thing to prove. And so you have to have the facts to support that kind of outcome. So that's where I am.
Yeah. Okay. Who haven't we heard from? Kathy, do you have any thoughts about this?
Yeah, I tend to go with the business attorneys on this, just because I form entities and manage entities more than sue entities. So I view it as, it would be changing the LLC Act drastically, and then I might tell my clients not to organize in Oregon.
Okay, does anybody else want to comment? I think we've heard from pretty much everybody. So I think our options are to, and I want to take a straw poll just so we can put a pin in this discussion, so we can move on. So I think our options are to either wholesale adopt Cody's proposal, to not adopt Cody's proposal, or to table it and ask debtor creditor to weigh in. So I think those are the three options. Okay, so can I see a show of hands on who wants to wholesale adopt Cody's proposal? Okay.
I just saw Cody and Aurelia.
Yeah, I got two. Who wants to wholesale not adopt Cody's proposal? Oh. Okay, 1, 2, 3. 4.
I think that's a majority.
Yeah, I think that is a majority. Okay, so we're gonna not even go with my third option there. But Teresa, to the extent that debtor creditor has thoughts on this, I think it might be an interesting project for a policy committee there to address.
Yeah, I think debtor creditor would have thoughts on it, and I think debtor creditor's thoughts on it would be what Cody and Aurelia are saying, and which I recognize they're correct about. I mean, I don't disagree with wanting to do this. My concern though is that I very much hear what the business folks are saying, which is if people aren't going to organize their LLCs here because of it, then we're not making any progress, much as I would like to make that progress. So,
Valerie, oh, sorry, Teresa. Valerie, Susan just popped up. Do you want to weigh in?
I was just going to say that no matter what the policy choice is, recognizing that it is a policy choice, and if anything's going to go forward, whether it's something that's set aside for a later date and discussion, that's fine. But I do think you need to get the feedback from various stakeholder groups, including the creditor section, before any proposals move forward, just because, as you know, it'll be something that'll be discussed when it comes up in the legislative process, and it's just good to make sure you have the feedback.
Well, right, and I think that's because it is a change. I mean, I think there are things that we have done that have been policy reflective, right? But that are not changes, but there are more changes to RULCA to reflect Oregon policy and decisions on transparency. So, okay. Well, I think that was a great discussion, and I appreciate your thoughtful proposal, Cody, and bringing it forward. And I appreciate everybody sharing their thoughts on it. Yes.
Valerie, one thing, and Cody, one thing we can do, and I think it's part of the traditional LLC process, is if you want to put pieces of the memo, I've also been taking notes about the conversation in the final OLC report when that's done, just so if anyone goes back 20 years from now and they're looking at it again and wants to see that this was discussed, we can certainly do that regardless.
Oh, yeah. I mean, I would think we would keep this in the legislative history, or however you classify that. And I think it'll be important for you know, if a court analyzing these issues in the future may, oh yeah, there was a problem identified. The group decided this was not the solution, but you know, who knows what happens down the line. That's fine. But I appreciate everyone's consideration of this.
Yeah, and even though this is not maybe the solution, I mean, I think that there is a problem, and I think it's a legitimate problem that you've identified, you know, and so trying to figure out what is a better remedy is certainly worth inquiring.
Yeah.
And Sandy, I mean, the little thing in the corner tells me we're recording, so this is going to be part of the public.
Absolutely, yeah. The notes, Cody's memo, everything is all part of the public process.
All right, good.
Yeah, I would just add one more thing. I am definitely sympathetic to the issue here. I just wonder if going back and looking at Oregon's version of the UFTA and maybe looking if there's some additions to make that a little more robust to get at some of these people that are abusing these entities and purposely trying to hide assets and doing nefarious things. I mean, I think there's probably already remedies for some of that, but I'm sympathetic to the scenarios you're talking about. And I'd like the idea of maybe looking at through that kind of a lens, because I think that act is really focusing on people that are really trying to hide assets. And so, you know, I think finding a better remedy there rather than in the entity statute probably is the route to go.
Well, and there is a new uniform statute that goes beyond the UFTA that a number of states have already adopted and Oregon has not looked at yet, to my knowledge. I'm starting to see it come up in matters involving out of state. So, I mean, there may be an opportunity to look at whether we should do that, but I think that would be a different work group than this one.
What's that other statute?
Oh, I knew you were going to ask me that. Hang on. Give me a second. I'll find the name of it and I'll put it in the chat.
Great. Thank you, Teresa.
Thank you.
Okay, so where are we? Are we done with 701? I think we're done with 701. David, is that what your notes reflect?
My notes show that we ended, we were kind of rushed at the very end last time.
Oh, that's right. Yeah,
finish it. So in my notes, it doesn't, I think we tried, but I did want to make sure that everyone was confident with that we were done with it.
Yeah, I mean, I have notes up all the way through A on 701. And then did we discuss B on 701? In a proceeding brought under A4C, which is I crossed out 4. Court may order remedy other than dissolution.
Yeah. I have incorporated the provision 701 4C about dissolution. And that was the last note I have from the last meeting.
Yeah.
I thought we had talked about 63661.
Yeah. Cody, I have that. That was related to it. Yeah.
Okay, so we were going to adopt 63661 1A.
Yeah. That's what I've got.
Okay.
I have the same, Cody.
Did we discuss the 63664 here? I don't recall doing that.
I don't think so. And I've got a note about 63631 too that I wanted to talk about. Let me pull that up.
Oh, and also I was thinking, I had 63661 2 and 3. Did we talk about including those into this statute somehow? Because those are the shell entity.
Yeah, I mean, I have a note that we're going to add in the 63661 provisions at
okay
4, because those are definitely policy decisions.
Yes. Okay, yeah. So my other thoughts on this was 63664, which isn't, there's no roll cut provision that's an analog to that, but I didn't know if we felt like that was important information to include or not. Venue and so forth.
I think we need to consider including it at some point as a part of the adoption, but the question is, where would we put it?
Well, I think you would probably put it after B, right? Or in a provision between 701 and 702. Although, wait. We have, oh, actually what we would probably do is we would probably put it after or before 708, which is administrative dissolution.
Right, that would
Or
be a
after
good
that,
place.
and then 709 is reinstatement. So I'm gonna make a note to talk about it there, Cody, if that would be okay.
Sure. So you mean like create a whole new section into
Yeah,
our version of ROLCA that
that's sort of what I was thinking. Because we've got the, hold on. Yeah, because we've got the administrative dissolution and we've got 7010 as a new section that talks about judicial review of denial of reinstatement. So, I mean, it seems that it would fit better towards the end of the section.
Yeah, well, I mean, I was just thinking that 701A4 is ROLCA's judicial dissolution provision.
Yeah, but I think it didn't seem to flow to me if we were going to put the grounds in there, which is the 63661 grounds for judicial dissolution. And then B is just, yeah, you don't have to do that, you could do something else. But then 63664, and then I think 63671 is the judgment of dissolution, and those seem to be more procedural.
There is no analog there is no part of ROLCA that has 63671.
Yeah.
So we want to consider whether we need to add that or not.
Yeah, but I think, we talk more, like, I think the first part of the 700 series talks about sort of the grounds and the acts and the operations of the LLC. And then the procedural stuff is at the back end of the chapter.
Right. 701 is events causing dissolution.
Yeah.
So
yeah, but then 702 is the how do you dissolve, 703 is how do you rescind dissolution if you want to, 705 is other claims, and then 706 is where we start talking about court proceedings. So that might be a way to but it's more court proceedings in the context of the choosing to dissolve thing.
Right,
So
but I thought the court for 706 was just really about, it's ultimately part of winding up, right?
Right.
It's about
That's why I say you
claims.
choose, how you do choose to dissolve rather than having a court step in and say you must dissolve.
Yeah. Yeah. I just kind of had viewed 704 through 707 as ultimately, how do you do a winding up after you have dissolved? How do you disperse the assets ultimately? How do you, marshal and disperse?
That's why I think, 708, the administrative dissolution provision, I think that and the judgment of dissolution provision and the judicial dissolution provision seem to go better together.
and I would concur with that. So
Okay.
So I've got a note in there.
So we'll sort of put a pin in 664 and 671.
Yeah, and I've got a note to discuss, when we get to that, if that encompasses everything that we need to include based on what we have in the RS provisions around there. I just okay. Anything else about that? 661. Okay, so everybody okay with there being some other remedy other than dissolution ordered, possibly in a proceeding? I don't think that's terribly controversial.
right.
All right, hearing no objection, let's move on to 702.
Wait, just one thing on that. The other remedy that what I'm thinking of is that in the event the court orders dissolution of the LLC, it could, or instead of ordering dissolution, it could order the majority or controlling owner to buy out the minority. That's one remedy. And then I guess other remedies would be the court telling the LLC to go do this, that, or the other thing to rectify whatever grounds that might exist for dissolution.
Yeah,
I think so. Yeah.
That's what I think.
We do have.
I'm sorry, Aurelia, what did you say?
Well, the corporate statute has a whole bunch of different remedies that are available. You could appoint a receiver, you could change management, there's all sorts of things that the court could tell the LLC to do.
Yeah, I just read it as a judicial flexibility provision that, you know, if they could come up with something better than dissolution, they should go there, or they could go
Yeah.
there.
Yeah, I
And
just,
under the common law, historically, some courts had interpreted their corporate acts authorizing dissolution under these kinds of grounds as prohibiting them from doing anything less than dissolution. And then Oregon had, in a case, gone the other way and said, no, if we can dissolve, we can do something less, whatever we deem just. And then that got codified in the Oregon corporate statute. And here it is in the LLC one.
Yeah, I mean, I like that. And I like the idea that they could courts could come up with the right answer. Okay.
Just one other point on that. I would note that in the notes, it provides that that subsection B can be overwritten in the operating agreement.
Right. The commentary does have that.
Right. Well, and recall that with regard to section 105, it says the operating agreement cannot vary the causes of dissolution specified in 701A4, which is this oppression and stuff like that.
But B can be overridden.
Exactly.
Yep.
And for whatever it's worth, there is no ORS analog to that subsection B. At least I didn't see one.
Correct.
Yeah, which again, I mean, I like the idea that maybe there's a better answer than dissolving the issue. Okay. Shall we talk about winding up?
Awesome.
David, do you want to start or should I?
Sure. I mean, either way is fine with me. So
Go ahead. I've been talking a lot today. I need to drink some coffee.
you make my life difficult. So the first one is on 702, it says a dissolved limited liability company shall wind up its activities and affairs except as otherwise provided in section 703. The company continues after dissolution over the purposes of winding up.
Yep.
This is similar to ORS 6371, and I didn't see any issue with it. If anybody has any discussion.
Yeah, I mean, I think the only difference between this and 6367.1 is that it talks about, you know, our current one talks about members and managers, but the intent of it is the same.
Exactly, yes. It's similar but not identical. So.
Okay.
And then the next one would be B1, and it just says, in winding up the activities and affairs in LLC, shall discharge the company's debts, obligations, and other liabilities, settle and close the company's activities and affairs, and marshal and distribute the assets of the company. There is no ORS analog to this, but again, I don't have any policy issues as to why we should oppose it or not adopt it.
Yeah, and when I read this, I kind of liked it because I thought, you know, if you have your carpet layers and they're trying to wind down the company, I think this gives them a nice roadmap. This whole section B gives them a nice roadmap for how they're going to be doing that maybe isn't in there right now. The only thing is that, you know, it does, I did want to get Jamie's thoughts on the Secretary of State delivering the form that's delivered. Because you deliver a statement of termination stating the name of the company and the company is terminated.
So we have the articles of dissolution, but we don't have a statement of termination. So that would be something separate.
Right.
So one of this whole Article 7 does, you know, envision different forms being filed with the Secretary of State. One of which would be that, the other one, you know, like a statement of dissolution, for example, and a statement of termination.
Yep.
So if we adopt this article, then we will have additional forms to file with the Oregon Secretary of State consistent with the article.
That's what I'm seeing. It looks like we would have to have another form. So we would have our articles of dissolution, but then we'd also have to have the termination form as well.
Does that give you any heartburn?
No.
Okay.
No, I think the biggest thing is making sure that people understand. It's hard enough sometimes to make sure that people understand what they need to actually file. And so just making sure that they understand, you know, the differences and that's clear, but I don't see any problem with that.
Okay. Yeah, I mean, because the 702, hi Kyle, 702B2, you know, basically gives that roadmap. And so I think that would be pretty easy to translate to a checklist or something for, you know, our carpet layer situation. Does anybody have any heartburn about that? Any concern?
I do, and although, you know, the only thing I would point out is that they're like what she's talking about, there's all of a sudden all these new forms to consider filing, and I think it puts some burden on the Secretary of State's office to make sure that what's filed is appropriate, you know, as opposed to in the olden days, you just file articles of dissolution if you did anything at all, other than just letting you know, an LLC be administratively dissolved.
Yeah. Okay. Any more discussion about 702B?
Yeah, I have one comment on B2. Does anybody heartburn with the word may? It says all that stuff A through G is effectively permissive and not required. It seems odd to me that it says may do these things, not shall do these things.
I mean, I think there are other ways to dissolve the entity, right? And so this is just a pathway to make that happen. You know, the administrative dissolution provisions later in the chapter still exist. So what David is talking about here, where you would just, you know, if you do anything, you could just let the administrative dissolution proceed like it does now.
But
I think it gives a kind of a roadmap.
Yeah.
This is, I mean, I get that. And usually administrative dissolutions are not intended and they file and reinstate. They're not intended to actually solve and let it go away. Not always. It's just, but again, it just seems odd to me that this is permissive because it really is a description of what typically happens in a true winding up.
Yeah.
I don't know.
What is
Jeff, I had the same question, and you look over to the ORS 63631, at any time following dissolution of the LLC may deliver to the Secretary of State articles of dissolution. So I guess you read our current statute, it's somewhat similar. We don't have the statement of dissolution and the statement of termination. I mean, that's definitely different.
Well, yeah,
right.
I hear you. It just seems odd that B1 starts out shall discharge and tells you what you have to do. And then you get to 2 and it's you may do these things.
Yeah, I mean, what is the situation? I mean, I think the situation that you're thinking about is you have an LLC that either does or does not want to put the world on notice that it's dissolved, right?
Well, that's 2A. That's one of them.
Mm-hmm. Yeah,
So-
but go ahead, Roberta.
So doesn't B just really provide added flexibility? I mean, it might put an additional burden on the Secretary of State's office, and in terms of, does the Secretary of State think that they need to provide forms? But it does provide the may provides additional flexibility for entities who don't want to go through that.
Or who may have no business activity. So let's say that you set up a whole series of LLCs that don't do anything, that have no assets, that have no operations. You know, what is because there's going to be cost associated with filing all this stuff, right? But when I read the section, I thought, okay, you know, but if you have an LLC where there's no risk of, you know, of someone saying, oh, well, I still think this thing exists. You know, it has no creditors, it has no assets, it has nothing. Then that's the situation where I think you might not go through the hoops and incur all the filing fees.
Yeah, to that point, you could literally, instead of taking all these actions, you could just let the company be administratively dissolved and not worry about any of those fees.
Yeah,
Which
because
I think is what happens most of the time.
It is what happens most of the time.
Right.
You know, and by taking the affirmative action to dissolve the entity, you're probably starting various statute of limitations. You're putting people on notice that it's no longer in existence. You know, and not waiting out that 5-year period where you might pop back into existence or whatever. So that's what I thought of when I read the provision, Jeff. And so I think the permissive language here makes sense to me.
I think it makes sense to me as well. And I viewed it as sort of include but not limited to, you know, in a way we could also just rewrite this section to include just subparagraph G, you know, but I think it would provide guidance, I think, to people who form LLCs in terms of what they need to do in the event they want to actually formally dissolve an LLC.
Okay.
Yeah, and the comment kind of explains that if you file the statement of dissolution, then that affects, it rescinds all the statement of authorities that were done before in terms of who can bind the LLC. There's some, you know, benefits an LLC may choose to take advantage of or not.
Yeah, I mean, it basically puts the bow on everything, right? Saying, okay, we're done, but you know, you may not care. So.
Well, the irony, I think, is that, you know, most LLCs don't really want to retain us to assist them in the dissolution because they don't really want to incur any more professional fees. But
yeah,
They don't want to incur them in the front end when we form it for them.
That's true.
Sad but true. Okay. Anything else on B?
I was just curious, and I'm sorry, David, if you covered it. What's the difference between the statement of dissolution and the statement of termination?
So you know, it's terrible. I don't know the answer to that off the top of my head without going back and looking at it.
I've never seen those two concepts separated. It seems like they do the exact same thing.
Well, but isn't it, no, I think, well, and maybe I'm wrong here, but isn't it you file the dissolution first and the LLC it just has to go into wind up mode. And then when you're done with the wind up is when you file the termination. And doesn't the LLC essentially stop existing upon filing the termination statement?
I guess I've never worked in a state that has these two separate filings.
As I haven't either, so it would be unusual.
Seems like we're doing another burden. If we could consolidate those, I think we'd be more consistent with other states.
So it would be interesting to know what the policy reason would be for the difference between the two of them and why they felt compelled to do that.
You know, my only thought on that is that it might be that most people let it be administratively dissolved. Those that want to go far enough to say we're filing articles of dissolution will do that. But every once in a while, somebody needs something that says we're completely done. And I think that's the only reason somebody might get as far as, you know, the statement of termination is if they had their own business reason why they actually needed to say we're finally and officially done. I suspect most people stop after, you know, 2A, after doing the statement of dissolution, if they even go that far. And there's no requirement to do both.
Yeah, but again, Teresa, I think the issue is, and David said it as well, I don't know any other state that even has this. So I think it's an additional burden that's unnecessary.
So some states, actually, I did look at, like Idaho has this when they adopted ROLCA. So some states have adopted it. I'd have to go back and look at my notes, but I don't know whether the state of Washington did or not.
I think too, Cliff, it's permissive, it's non-mandatory. So to the extent that someone wanted to file it, like as Teresa's saying, to just say, okay, we're done, there's no more to be done here. I mean, I do think there's some value in that because like these wind-ups can last years.
Yeah. I don't have any major objection to it. It just seemed odd. I'm willing to continue on.
Fair enough. Okay. Any other discussion on B, section B? Okay.
Really quick, I just want to make sure I was following because we went back. Where are we on B? Are we adopting? I'm
yes.
Just trying to make sure. Okay.
Yes.
Just want to make sure.
And it largely parallels some language we have, you know, in that permissive stuff. It provides a better roadmap, I think. Okay.
Perfect. Thank you.
So the next one, subparagraph C and D, really are in the weeds sort of provisions. They basically just talk about procedure to follow for winding up if the company has no members. And there is no ORS analog for that. So this would be new. Again, I didn't see any policy reasons for why we should not include this, or include them, I should say.
Yeah.
I had a question about this. So when it says legal representative of the last person to have been a member, does that mean like a personal representative?
That's
or
how I read it.
somebody in that capacity, or does it just mean the last member's lawyer?
I would be in the Valerie category there. So there's
You should
something.
make that very clear, though.
Right.
I mean, I think we would want to be clear about that, because I'm not sure that just dumping this on the last member's lawyer is a good idea.
Yeah, I wouldn't want that
Well,
responsibility.
again, there's there's may permissive language in here, right? And so, you know, my thought on this when I read it was that, you know, the SMLLC interest would be an asset of the estate if it's an SMLLC, right? And so the fiduciary would have the power to act with respect to that asset. And then if someone dies, you know, without a fiduciary, but there's somebody has a reason to do it, then maybe you would get a lawyer involved. And it would make sense that it would be the lawyer of the last person, because they're most likely to have records. But I think the logical path goes through the estate's fiduciary, be it a trustee or a personal representative.
I just wonder if we ought to clarify what's meant by legal representative.
So legal representative, I just did a search through the document, and it is mentioned in chapter 5, Teresa. So I don't know whether it's totally defined, but it is mentioned in that.
Yeah, I did the
Well,
same
and
thing.
it's
It looks
talking
like it comes up.
specifically about people dying.
Well, yeah, but I mean, it does talk about legal representative, so, you know.
But it doesn't provide any further definition of what is meant by legal representative elsewhere. I did the same thing you did, Roberta.
I wonder if it's a matter that we can just handle with some commentary that we interpret it as meaning, you know, a fiduciary such as a personal representative of a deceased member.
Or like a conservator or guardian.
Executor.
What about a bankruptcy trustee? Does it include a bankruptcy trustee for a member that filed bankruptcy?
Or a
That's a
trustee
good question.
generally.
Well, I would think wouldn't bankruptcy law override whatever this meant in that regard?
I mean, a bankruptcy trustee is going to get whatever rights is given by state law. Probably.
Right. But so, I mean, as to if it has no members, who is the bankruptcy trustee stepping in for then?
Well, let's say, for example, the member was a corporation and the corporation filed a Chapter 7. Does that mean that the bankruptcy trustee then is the one that can come in and wind this up? Because maybe it does, and that's probably okay.
That may well be it.
It certainly makes sense that it be a personal representative. And I think in section 504, when they're talking about, you know, a person dying, a person's legal representative can exercise their rights. I assume that meant, you know, personal representative under the probate type laws. But here, where there's no context, you know, am I somebody's legal representative just because I'm their lawyer?
Got it.
I don't think legal representative means lawyer.
I don't either.
Then maybe we ought to say so.
Well, but the question is, where do we say so? Because I think there are types of legal representative, not lawyer, that beyond personal representative that maybe we want to have the ability to deal with this. So I think what Michael is saying makes sense, that perhaps we include commentary in here about this, that,
Well,
you know, not it.
yeah, but I mean, if we go back to our carpet layers, who's the personal representative of the carpet layer?
Their spouse.
Well, it'd be whatever their will would provide for, or
Well, that's if they're
right. But that's what I think that this is talking about.
Roberta, we talk about personal representative means executor in Oregon.
there you go.
So.
That sounds like that should go in the comments.
Okay, any other discussion on this? But I have a note about
Yeah.
adding commentary.
Valerie, I have good notes of the commentary too on that.
Okay, good. Respondent will not lawyer. Okay. David?
So the next one is basically, it sets forth subsection E, sets forth procedure for members or a transferee
Oh,
to.
are we skipping D?
Oh, I thought I did them in combination with each other.
Oh, okay.
So we can certainly separately discuss D if you want.
I don't feel strongly about that, but does anybody else feel strongly about that? Because it talks about the situation where the legal representative declines or doesn't do a good job winding things up, that the other folks can appoint someone.
Right. And again, there's no ORS analog to this, so
Right.
they're introducing a new concept.
Yeah, but I think it's basically that decision tree of who has the ability to act
Right.
for the dissolution. I was fine with this section, so I'm happy moving on, but I just wanted to flag it. Okay, let's move on.
Awesome. So subparagraph E, has a relatively lengthy procedure for a member or transferee to judicially supervise the winding up of an LLC. Based on my review of the ORS, the closest analog is 63.661B, which requires a finding that it is not reasonably practical to carry on the company's business in conformance with its articles of incorporation, organization, operating agreement, whereas E requires that the member establish good cause. And then the other potential analog is 63.373, which also requires that the member show cause. We are introducing one of the ORS 63.661, which is one of the ones is sort of out there that we want to consider, moving into ROLCA or into our version of it. So anyway, I didn't have any issue with this particular section unless other people had heartburn with it. It is
I do have a note about, looks like 409 does not apply. So this. So 409, which starts on page 107 in my printout, is the standards of conduct. I don't know why that is. Does anybody else have that?
The commentary states that section 409 does not apply to a person appointed under this section. So
yeah, and that's the standards of conduct. But I think it's the fiduciary responsibilities that you owe to the other folks, other members, and that the judicial dissolution provision, I think, substitutes, right?
Yeah, the commentary says agency and contract law will determine the person's duties. So.
Yeah, and that makes sense to me, but I just wanted to flag it.
Right.
I wonder if we should mention ORS Chapter 37 and the receivership code as being potentially involved here, because I know it talks in the comment about how this could be a receiver, could be agency law, could be, contract law, could be something else. But typically reading this statute, the appointment of a person to wind up the company's affairs and activities, to me, would suggest that this kicks us into the process set forth in ORS Chapter 37, the receivership code. Because when a court appoints a person to do something like this, it's pretty much going to fall into that rule.
Yeah. I mean, do you think it's necessary to do that in the text of the statute itself, or would that be an appropriate comment to make?
I think it would make sense to put in the comments, but I think we should.
Yeah, no, I agree.
I'm reading this slightly differently, or I think this is getting at something different than where the conversation's gone. The way I understand this provision, what it seems to be getting at is if the company, if the people who are in charge of the company, for whatever reason, can't be trusted to wind up the company and complete the dissolution of the company, the court may appoint someone to do that for them, and there may be reasons for a court to do that outside of any kind of financial issues. For example, right? The managing member of the company is just dragging her feet because she disagrees with it, or because the timeline benefits her to drag her feet, and a minority member wants it all done, wants the liquidation complete, and wants out of the business, and wants everything terminated. And so that minority member could bring in action under this provision to force the managing member to actually complete liquidation and termination of the business. I don't see this as dealing with kind of bankruptcy or receivership issues.
I agree.
I would agree. I have a situation where it's a multi-member LLC. One of the members is a manager. It has multiple properties, and they're going to liquidate and do in-kind distributions. And the concern is the manager, who's also a member, may play some favoritism in terms of splitting up the assets. Again, not kind of a situation that a receiver would be in. So I too think this is sort of separate and apart from receivership and serves a different purpose.
So,
yeah, and Jeff, that's the situation exactly where I think one of the members might want to avail themselves of this provision and get someone else appointed to be in charge of the process.
It essentially, correct, an independent third party who would not play favoritism in an in-kind distribution of the assets and sort of getting the best real estate. The manager would get the best one, and the others would not get the best piece of property necessarily. So
like
that's just
receiver?
independence to make the decision on how to do the in-kind distributions.
Yeah, but a receiver under Oregon law is going to be any person appointed by the court.
That's what I'm saying, is that sounds an awful lot like a receiver to me. Roberta, I think you had something to say too.
I did, and it was just about 409, which I think is a default provision.
Except that it specifically doesn't, it specifically.
Well,
yeah.
So I guess it's okay. I was sort of thinking that
it's a default provision, but I think it's a non-exclusive default provision, right? So there are situations where, like this one, where there may be other existing rules that apply.
Right.
Well, isn't the question, do we want the receivership law to apply? And if not, then can't we carve out, put something into this language that says that receivership law is not intended to apply?
But I think what I'm wondering, Jeff,
I think you do.
Sorry, I think what I'm wondering is, I think that we're talking about two separate situations here. And what Teresa had proposed was putting this in the comments that, in situations like this, the receivership law would step in. If you have facts that you think the receivership law should not apply in, then maybe it makes sense that we would also put that in the comments, that, in these circumstances, we would, because I think examples will be helpful for people to understanding how to navigate this.
Well, and I think we need to go back to the definition of what a receiver is. Under ORS 37.020, receivership is the process by which a court appoints a person to take charge of property during the pendency of an action or upon a judgment or order entered therein, and to manage or dispose of the property as the court may direct. So a receivership under Oregon law isn't just what you think of as a creditor's dissolution of the company, like a mini bankruptcy type proceeding. A receivership is anytime the court tells a person to manage property, then these rules kick into effect. And I think you do want them in effect, because in your receivership order, you can spell out exactly the scope of what the receiver has powers to do or not do. Mm-hmm. And it gives you the roadmap of what can happen. And that was the whole purpose of the receivership code, was to bring a lot of clarity to that area of the law and make it so the court can handcraft the relief to match what's going on. And there are certainly receivers of solvent corporations who come in because, for example, the two owners are deadlocked, and their job is to simply operate it well and keep it going and being profitable while the two owners sort out the problems. It doesn't have to be a dissolution. It sometimes is, but in fact, mostly is. But there are plenty of situations where people use them temporarily to, just manage property. I mean, it's a receivership when you have a family law case and nobody's taking care of the dog. I've seen a receiver appointed to take care of the dog. It's kind of an odd case. I wasn't involved in it personally, but somebody was presenting on it at one of the debtor creditor situations, one of the debtor creditor meetings. Kind of interesting.
Well, it's interesting. ROLCA clearly wasn't drafted to anticipate our receivership statute. So it's kind of an interesting overlay.
Yeah,
I'm a little bit concerned about it essentially saying that the statute applies. And Teresa, you know it backwards and forwards. I don't. Without really looking at that statute and its implications of how it would fit here in this context.
Your mission, should you choose to accept it, is to take a look at the receivership statute and see if you can come up with a situation that, you know, you think that it would be a problem for. And then I would love to have you circle back with the group next time if you don't mind.
Okay.
Because I want to make sure that we're being as clear as possible. But I agree with Teresa, and that I think a lot of the situations, at least that I can think of, but I know your firm deals with a lot of other sort of distressed business situations. If you can think of something that is not covered by the receivership statute, then I think we need to circle back to it. That sounds reasonable.
I accept my mission.
All right, thank you.
Jeff, give me a call when you find something and we'll talk.
Okay.
Okay, so Jeff and Teresa, we will hear from you next session. Sandy, can you remind me, please?
He's taking a break.
Yes, no, I'm here. Yes.
Oh, you're back. Okay.
I've been here. I'm listening. Yes, Valerie.
However, speaking of taking a break, I'm out of coffee. So why don't we take a 10-minute break so I can go get more coffee, and then we will see you all back here in about 10 minutes.
Sounds good. I'll pause the recording.
Great.
So Valerie, you know, I digress, but you know, Cliff and I were talking about the statement of dissolution versus statement of termination, and whether we really need to consider whether we need both. So maybe I'd be happy to take a closer look at that in the, you know, in this context to see whether that's just, those are superfluous, but, you know, but talk about that at our next meeting. And Cliff, Cliff and I talked about like the state of Idaho. So Cliff, just to play devil's advocate, I see in the Idaho statute, both of those statements in 702. So, but we can talk about that.
Yeah, my only point was that if you go to their actual business forms, they don't have.
Oh, they don't have an actual form.
Yeah, they only have the one form. So
we won't ever know what it looks like.
Yeah.
Okay, well, we'll look forward to hearing you update us next time on that.
Okay, it does seem somewhat redundant to some degree, but maybe there's a good policy reason for both of those.
Well, I mean, I thought when I read it that it was just the putting the pin in, we're done, don't bother us anymore.
Oh, that's how I look at it as well. But we can revisit the issue.
Okay.
I don't have any.
Yeah, and just so you know, Valerie, that if you look to, it's like section 103D2 and 302H, they're treated the exact same for notice purposes. Literally, they're So I'm just kind of at a loss. Cody had some good thoughts on why it may be in terms of authority and possibly providing some personal liability, but we're all kind of still just grasping at straws.
Okay, well, I will look forward to that discussion at the beginning of our December meeting.
Okay, we can keep it down to the 30 to 60 seconds.
I will buy you a drink if you can keep that discussion down to 30 to 60 seconds of your choice.
Okay. Well, we can actually go out and do things like that. So.
Right. I mean, I don't believe it can be done. So.
Right.
All right. Where are we? We are on section 703, which is a new section.
So just to be clear, we finished E. E was good. I have notes, but we decided to accept it.
I'm okay with E.
Okay.
Yeah, I think we're done with E. But for Jeff's homework for next week.
Yes.
And Teresa's homework.
So 702 allows for the rescission of a dissolution, and there is no ORS analog to this. And again, I don't really see any policy reasons for why we should not consider adopting it and ultimately to adopt it. You know, subsection A basically says the company may rescind its dissolution. Subparagraph B says the prerequisites to rescission.
Back up. So subsection A says a company may rescind unless a statement of termination has become effective.
Ah,
So,
there we go.
Wanted
So
to
there
flag
is
that for
a,
your
you're right, there is,
attention.
I spoke too soon, so.
Yeah. So,
So
you know, I think that's the no takebacks document.
That's a good point. I even have that highlighted.
I'm sorry, Valerie, could you say that rule again, which one you mentioned?
Yeah, so it's 703A, and it says, and this is a new rule, so we don't have a corollary to this in current Oregon law. And it's a provision that allows the company that has filed articles of dissolution to rescind that dissolution. And it says you can do that unless you have filed a statement of termination applicable to the company. So, you know, I think if we're going to be addressing this statement of termination, sorry, the sun is really obnoxious. If we're going to be addressing statement of dissolution in our discussion, or statement of termination in the discussion next week, I just wanted to flag that because I think this section implicates that as far as putting a pin in, okay, there's an actual change happening here. Okay.
Yep, and frankly, that seems to make sense. At some point, you can't rescind
Right.
a dissolution.
Well, and that's consistent with my comment earlier, where a dissolution, the company doesn't cease to exist. It just has to go into wind-up mode. A termination means essentially the company doesn't exist anymore. Once it's gone, you can't bring it back to life.
Right. So, so I don't have a problem with 703A, but you know, to the extent that we're talking about statements of termination next week, I'd like to have that addressed, please.
Okay, so we can do that.
Okay, B.
So B is the prerequisites to rescission, and essentially they just requires the affirmative vote or consent of each member, and the limited liability company has delivered to the Secretary of State a statement of dissolution. So here we go. Here comes the so as a prerequisite actually to excuse me, I'm losing my voice. To rescinding, you would actually have to have filed a statement of dissolution. So, and then subsection C sets forth the effect of the rescission of dissolution, and it just basically says that the company can continue to move forward as if it had never been dissolved.
So David, am I reading this correctly? If you filed that statement of termination, the rescission under 703 is no longer available?
That's how I read it as well.
Okay.
We can again revisit that issue again next week, but I think that's, once you file the statement of termination, then you're really, the LLC is done forever, I think.
Yeah.
Okay, that makes sense to me. Yeah, and the only note that I have with respect to B is just that there's this window, right? And so I think that's going to be more of an educational thing in dealing with the bar and just educating them about what that window would look like. Okay, 703. Okay. C. So basically, if you rescind your dissolution, you're back to where you were before you filed the articles of dissolution. So you continue on with your affairs, any liability that, and so sub C2 talks about liabilities the company incurs after the dissolution. And it's basically treated as though the dissolution had never happened. And any third party rights would be treated as though the third party had not, the dissolution had not happened. So it's basically you go back and you wash out the dissolution as though it had never existed.
Right. And the purpose of, under the commentary, the purpose of subsection 3 is in fact to protect, third parties.
Yeah. I mean, this all seems pretty non-controversial to me, but it is a new section. And, but I think, again, sort of similar to what we were talking about, the road mapping that happened in the prior section, with respect to wind up, I think it's good for folks who do not necessarily have counsel, and it provides an opportunity for a take back. So, okay. Any discussion, questions, concerns? Look at us. I'm so proud of us. Okay, 7:03, done.
I think it is non-controversial.
Yeah. Yeah, I mean, we've debated non-controversial stuff before, though.
Right.
Okay, 7:04 talks about known claims against a dissolved limited liability company. And the parallel, I think, at least what I've got, is 63-641.
Right.
So, you know, we had discussed addressing 641 earlier today. So I just want to make sure that this is our parallel. Now, I don't know. So do you want to walk through this? Do you want me to walk through it?
Sure. So section 704 and section 705, you know, they incorporate into the WOLCA portions of the revised Model Business Corporation Act. 704 deals with known claims against a dissolved LLC, and 705 deals with any other claims. And as Valerie was saying, section 704 is nearly identical to ORS 63-641 for all intents and purposes. And then section 705 is nearly identical to ORS 63-644 and 63-645, but again, they're not identical. So there are analogs to each of these. Under section 704 is divided up into 3 subparagraphs. Subparagraph A deals with, you know, the fact that the company may give notice of of a known claim. And then subparagraph B sets forth what the requirements or what are needed to be set forth in that notice. And then subparagraph C says the claim is barred if the notice requirements are met, and the requirements of that particular subsection are met as well. And then subparagraph D says that this section does not apply to contingent claims or claims based on an event occurring after the dissolution date.
Yeah, and so the parallel in 63-641, A is very similar to 1.
Right.
You know, and B contains the requirements, which is what we have in 63-641 2, you know, and
right, they are
sets forth the same info, A, B, C, D. And then C basically says the claim against a dissolved company is barred, which is parallel to 3.
Right.
And then the language in C2B is parallel to section 4. So really the only change, I think, is D on page 149, which says the section does not apply to a claim based on an event occurring after the date of dissolution or liability that on the date is contingent, which I think is similar to 4 as well.
It is, yes. The wording is not identical, but I don't see that there's any material differences between OR 63-641 and section 704.
Yeah. So, you know, my recommendation would be that we adopt it because it's basically the same as what we've got now. Any concern, questions?
I'm just curious on D. So what does apply to a claim occurring after the date of dissolution?
So my guess is you would go to section 705.
Okay, gotcha.
Yeah,
okay.
And it's the same language that we've got in 644 sub 4 or 641 sub 4 now. You know, so to the extent there's interpretation about it, it will just carry forward.
Well, that's a good segue into section 705.
It is. All right. Checking off 704. Look at us. All right.
Yeah, this article really, well, famous last words, I don't view as
don't
controversial.
Okay. 705 talks about other claims against dissolved limited liability companies, and it is it's longer than the prior one. But, as David pointed out, it incorporates elements of 644 and 645, which the unknown claims language in 644, and then the enforcement of claims against dissolved limited liability companies. Okay.
Again, I didn't really see any material differences between the wordings of the two statutes in this section.
Yeah, and they roadmap pretty well against each other, actually. I went through and I was like, okay, well, dissolved limited liability company may publish notice of its dissolution, request persons having claim present them in person, which parallels 644.1, and then B is what that notice must contain, which is sub 2 under 644. And then, basically says if it publishes notice, which it parallels section 3, which is C. And then the language starting with D parallels the 645 language. And so we're on page 150.
Which is identical, actually. There is one difference in, so subparagraph C, which are the conditions to claim being barred. So subparagraph C in ROLCA requires that the claimant commence an action not later than 3 years after publication of the date, while ORS 63-644 requires that
5 years.
In 5 years. So the question is whether we want to go with 3 years or 5 years.
I generally, and that's all language is also in sub 3 B3. My recommendation would be that we stick with the 5 years.
As would be my, recommendation as well. So we're consistent with the ORS.
Yeah.
David, what have our other surrounding states done on this point? What's their limitations period?
So I looked at, I'd have to go back. I can't recall what Washington did. So I'd have to go back and revisit that issue. But I'm pretty confident Idaho did the 3 years.
Yeah. I mean, Idaho basically wholesale adopted the act, which is why that guy who came out and talked to us was so excited about the act. But I think that there's a policy decision that's been made with respect to the 5 years, and so I'm comfortable keeping that. Does anybody have concerns about just going with what Oregon's done in this case?
So Idaho used 3 years.
Yeah. Okay. Hearing no additional discussion. Is there any additional discussion? Everything we see. Okay. So the situation D talks about claim not barred under this section or 704 may be enforced against a dissolved limited liability company to the extent of its undistributed assets, which is exactly the same language from 645 sub 1. And then sub 2 is the clawback provision that a lot of people forget about, where if you have assets that have been distributed to a member to the extent that, and there's debt or an undisclosed liability out there, that assets can be clawed back. But we have that provision now in 63-645-2. And I see that happen with entities, for example, that we had a real estate entity that forgot that the city of Portland has a business license tax in McBit, and so they didn't pay it. And so we had to get there was a clawback from the members to the extent that they had gotten a distribution to pay that. So, I mean, I think this provision essentially parallels our existing law. I mean, it does parallel our existing law.
It does, it's identical.
Yeah, it doesn't expand it, it doesn't contract it. It's basically what we've got now. And so I would recommend adoption. Okay. All right. Court proceedings 706. This is a new provision.
Yeah, totally new. So the way I viewed it supplements section 705.
Mm-hmm.
And there is no, you're right, as Valerie's saying, there is no ORS analog to it. And again, it's derived from the Model Business Corporation Act, as well as in the same manner as, the section 704 and 705 were derived from that act. And I'm not quite sure why it's needed, but, having reviewed it, I don't really have any issue from a policy perspective with it.
Yeah, do you want to walk through what it says?
Sure. So subsection A essentially permits a company to file an application with the court for determination of the amount and form of security provided for payment of claims that are reasonably expected to rise after the date of dissolution. And which again is unusual. Subparagraph B allows for, it just states that security is not required for any claim that is reasonably anticipated to be barred. So the whole idea of even providing security and that sort of thing is totally new.
Yeah.
Subparagraph C basically sets forth it sets forth the notice requirements to follow in order to take advantage of this section. And then subparagraph deals with the appointment of a guardian ad litem for unknown claimants. And then subparagraph E provides that a company that provides security ordered by the court satisfies the company's obligations with respect to claims that are contingent, and such claims may not be enforced against a member or transferee on account of an asset received in liquidation. So it gives some sort of finality to the process.
Yeah. Yeah, and Teresa and Cody and Aurelia, I'm curious about your thoughts on this section because it is new. You know, because it provides a process we don't currently have to dispose of this type of claim.
You know, I was thinking about that because it seems to me like it could be used for someone for nefarious purposes if they wanted to cut off all claims and just pretend they didn't know who their creditors were. So I do have some concerns that it could be abused, and I'm not terribly sure how useful it is.
I'm not either, to be honest.
Because I was sort of thinking about the example you just gave about the people who forgot about the business tax in Portland. I mean, if they had gone to the court and said, we don't think we owe anybody anything, but how about we put up $1,000 bond and you'll give us a complete discharge, then would the city of Portland have been out of luck?
Right. I mean, that's my concern about this. I mean, I like it from the idea that it provides finality for creditors, but you know, the whole idea of an unknown claim is that you're not necessarily sure what the amount is, right? And who you owe.
Right.
I mean, it provides for the appointment of someone to represent, like guardian ad litem in paragraph D on page 152, to represent all claimants whose identities are unknown. You know, in that circumstance, though, would someone catch? I mean, would someone catch all of these liabilities?
Well, and the problem is that your ability to bar a claim is only as good as the notice that you give, right? And so you wonder about, say, the manufacturing company that tries to use this process when it closes its business, but has been spewing defective products into the world for years. And only later is it determined that people are getting injured by those defective products. And those folks wouldn't have paid any attention to a notice because at the time they were injured, they didn't know that the product was defective.
Right.
You know, at the time that this notice would have been in the newspaper, they wouldn't have thought it was defective. It was only when they were injured 3 years later that they learned it was. And I mean, you're trying to cut off all those rights to people who really haven't had due process. And so I'm not sure how effective this would be anyway.
Michael?
I guess, and you raise good questions, Teresa. Going to Valerie's example, I guess it tees up the question when you look at 704, what does it mean by a known claim? And I guess I read it broader than someone's subjective knowledge. I think known in that context would be known or should have known. And in Valerie's example, they should have known that there was City of Portland taxes that are doable. So I don't think that can be measured by one's subjective knowledge. And so getting back over to 706, it talks about a dissolved limited liability company that has published a notice under 705. Well, you're not going to publish a notice you're not in 705 with respect to known claims.
Right.
That-
So
that's
we're just
really-
talking, I mean, I think the situation that Teresa's talking about, where, for example, you may have environmental pollution that's not discovered until a couple years afterwards. I mean, I think that's maybe a better example. Or maybe there's a contaminant that they don't know enough about to be able to assess the relative cleanup cost, you know, for a period of time. I mean, I am generally not in favor of this section. And part of the reason is that because I think in 705, we have a period at which point, you know, you have to submit a claim, right? And so that's the current law. If you don't submit a claim within a period of time, it's essentially time barred unless some other statute applies. And the other statute would apply in the case of the environmental pollution, right? Where you might have a longer statute. You know, so I don't necessarily see the need for this process. And that's why I was curious what Cody, Teresa, and Aurelia had to say, because I think we understand in our current system how those claims would be adjudicated or, you know, addressed. Michael, do you think that there's a need for this section?
You know, I'm not a litigator,
No, I
so
know.
it, you know, would be a bit deferential to the litigators on this. I mean, that being said, I guess it maybe adds some elements to Oregon law if an LLC that wants to go into dissolution and needs an exit that provides with some certainty. I would presume that the going before the court would require any interested parties be given notice of that proceeding.
Oh, I think so, yeah.
And so you know, you can't use, I don't see this as a section where you can use it to hide the ball and be nefarious. I mean, hopefully, you know, if a particular creditor is implicated in this and the judge sees that creditor hasn't been given notice of the proceeding, that they're going to put the brakes on and say, you know, give that person notice and allow them to object or respond to whatever plan you're talking about here. So I guess I'd have a hard time seeing this could be used for nefarious reasons. And I think for honest, upstanding people, it maybe provides a way to navigate, provide security potentially for, you know, debts and that sort of thing. So I think it's a useful tool for honest people that just want a little bit more certainty about, particularly when you get into the 705 unknown claims.
So would you be more comfortable if there were a shorter claim period under 705? Because right now what Oregon law has is 5 years. And when we talked about, you know, we talked about adoption of 705, we said, well, why don't we adopt the Oregon period? You know, but there's more certainty after 3 years, right? It's a shorter period of time.
Well, I guess I'd be reluctant to depart from a legislative decision on what the right time period should be under that section. I mean, current law has 5 years, and, you know, I think I would stay with our decision to keep it at what existing law provides.
Mm-hmm.
So I would agree with that. So the RULCA drafters apparently didn't consider this a particularly controversial section, as there is virtually no commentary. There's really no commentary to it at all.
They adopted the Model Business Corporations Act.
Yeah.
The only thing we may want to consider doing is see whether there's any commentary to the section 1408 of the Model Business Corporation Act.
Yeah, I'd be curious, somebody looking into that. And
So
also,
I'd be happy to look
what's
at
the
that.
case law and commentary about this provision either under RULCA or in the MBCA. I'd be curious what you know, what are people saying about how those provisions work? How has it worked in practice with, you know, any relevant judicial decisions with the commentary to the MBCA?
I agree with that because I'm uneasy about this statute, and I guess I don't share Michael's view that the nefarious people won't find a way to take advantage of this, because I think they could and they will.
But don't you agree
I don't
that
feel
a judge
strongly
is going
about.
to have interested
Go ahead.
parties given notice and get them into the courtroom to address what's going on that could potentially affect their rights?
They
You
may
know,
not
I
think
think
they
it
are.
then comes down to the nefarious people telling the court that they've given notice to everybody that they think they should know about in the way that makes sense, but actually using the way that makes the least sense.
James, I think you were trying to say something.
I don't feel strongly about this provision. I think the practical example of when one might use it, at least the only one that comes to mind from clients I've represented, is if you had a client that supplied construction materials and it's been around for 50 years and they're finally going out of business. They sold stuff in the 70s and 60s that had asbestos in it. And those claims show up, every 2 or 3 years, they might get sued and be named, because some person down in California bought some roofing materials that got shipped from here. I mean, there's those kinds of claims. And it would be nice for that client to have a way to just set aside a chunk of whatever's left and say, look, this is what we're going to set aside. We don't have to wait the full 5 years to enjoy the benefits of the rest of whatever we have upon liquidation. That's kind of a marginal situation and benefit in my mind. That's the example of when I think it could be used. But if that were my client and we didn't have this provision, I would just advise them to get tail insurance on all their policies. Go ahead and dissolve, publish your notice. You've got a 5-year window, get a tail policy that stretches the 5 years and call.
And I would point your attention to the comments where Mosen dropped the official comment to the Model Business Corporation Act 1408 in.
Yeah, a tiny chunk of it got cut off, so I just added the rest there.
So Mosen does, I'm looking at 704 and it's referring to the Corporation Act 1406. Does that commentary define known claim? Just
Let me
wish we had
look.
better commentary. Because I think that's a pivot point when you look at the difference between 704 and 705, and then that has implications when we get to 706.
So Michael, your question is if 1406 of the MBCA provides more insight into what they define as a known claim?
So I would argue that 706 is meant to supplement 705, but I don't know if that answers or addresses your concern.
Well,
I think that's the
you're not,
question.
if you have a known claim, you can't get into 705.
Right.
And if you're not in 705, you're not in 706.
Well, I don't know if ROCA has any definition of known claim. I didn't remember seeing one, but I can tell you there's a whole body of law in the bankruptcy world about what constitutes a known claim, that you would, run the risk that it would be imported here.
Well, it does have a definition of known. ROLCA does.
You're back in the definitions, Cody.
Yeah, which would ostensibly apply here. I don't think it's in the definitions. What is it, 103, something like that? Yeah, 103. A person knows a fact if they have actual knowledge of it, or if they're deemed to know it under either D1, which is when you know about certain certain Secretary of State filings. And then it also talks about if you are deemed to know it under law other than this act, such as a property recording statute. And then that's knowledge is separate from notice. Notice being if you have reason to know of it, or again, if you're deemed to know it because something was filed. So anyway, they define the knowledge as actual knowledge or sort of constructive knowledge. I don't think they define it to include should have known.
No, there's definitely not a should have known requirement in there.
Which
Also
would
throw
take it out
out-
of that tax example that you gave, Valerie, because they certainly should have
Yeah.
known
Yeah,
about the
they-
business
I mean,
income
they- yeah.
tax, but apparently didn't.
Yes, they should have known.
Yes.
Well, and it strikes me that since this is applying to contingent claims and claims of uncertain amount, that you would know of a claim even if it's a contingent claim or a claim of uncertain amount, right? Or is that wrong?
Well, do you think that James's building supplier clients know of claims under that circumstance just because they get them every few years? Does that mean they know they'll get more? I mean,
Well, I'm looking at what Mosin dropped in the chat, and I'm trying to understand the commentary because it makes it sound like that claim, the product defect claim, where you don't actually have a plaintiff yet, it doesn't make it sound like that is a claim. Whether it's known or unknown, it's not a.
I'm sorry, James, you cut out. Whether it's known or unknown.
It doesn't appear to be a claim under the commentary that Mosin dropped in the chat box. Known or unknown is not the deciding factor. It's not even a claim yet. So I'm trying to figure out how that.
I don't think the commentary, I put in the commentary for 1406 about what is a known claim, and I don't think it's particularly illuminating on the questions that we're asking here.
Not really.
No, I don't think so.
Well, but it seems to me that the issue about the the potential product liability claim, we've been selling these products, we don't know if they're going to injure somebody down the road, or maybe they're cancerous or something like that. Doesn't sound like, unless you, even if you reading this definition of known claims that from the MBCA, it doesn't seem like it would be a known claim unless someone has actually said, I've gotten cancer from your product, or I, had your product blow up in my face, or what have you. The other thing that I thought about looking at this is they keep talking about products liability in the commentary of the MBCA. In Oregon, we have a statute of limitations for product liability cases, which is 2 years from discovery. So in other words, indefinite. But then we also have a statute of ultimate repose for those actions, as well as for negligence actions, each of which is 10 years. And so, you've got 10 years worth of claims. And so in a sense, it doesn't matter whether you have a 3-year or a 5-year bar for these, these unknown claims. You're still going to have claims that come
But
for
Cody,
many years after that.
That's what I was saying, is that, the 3 to 5 year claims are sort of the 3 or 5 year claims. They're sort of the run of the mill claims. There may be other statutes of limitation that apply, right? And I don't know how those would be adjudicated under this provision, because I read this and I say, okay, so would you have to have the guardian ad litem, address all of those products liability claims to put them to bed? Or, because they may not be knowable at the point of dissolution. So that's my concern about this section.
Yeah, that's exactly right. How do you, even if you don't even do this until year 5, where you come up with this bond amount, how do you know even in year 5 what claims are going to come out in the following 5 years after that? You're just making it up.
Right. So how are we feeling about this section? Do we want to take a straw poll? Do we want to think about it? Is there additional research that we should ask law clerks to do on this?
I mean, I'm generally in favor of having more tools, but I agree that there seem to be some questions about adding this to the toolbox. I'd be really curious to know which other states have adopted this, and if anyone's been using it. Is there a case law out there? How has it been used effectively or not?
Yeah, I think that's a very good point.
So it would be the sort of scope of states we would look at.
I
Well,
would think you could just do searches for who has adopted, MBCA 1408, who has adopted this section 706. So you could probably do a word search just based upon, some key phraseology from this statute and find judicial opinions discussing the statute.
yeah.
I guess from my perspective, it's kind of looking at the states that may be considered for formation, which really is Delaware and Washington.
Okay.
So Washington didn't enact this.
Yeah.
And I'm just sort of one thought I had about it too is who should we put the risk of loss on? Should it be for these claims that we don't have any idea, if and when they may materialize or how big they will be? Should that risk of loss of not having set aside enough money be on the people who run the company and know what's going on as best as anyone can know it? Or should that risk of loss be put on all the potential claimants who are, who may not even be identified and represented only by a guardian ad litem, who may not, have a very, very strong incentive to advocate for the biggest pot possible.
So
I'm not a litigator, obviously, but it seems like some of the issues you're bringing up could be dealt with outside of the act. And where I tend to look more is if we want corporations and LLCs to be formed in the state of Oregon, we need to have an act that doesn't punish them for choosing Oregon.
Right, but you mentioned, or someone mentioned Washington as being a chief competitor for Oregon, and Washington didn't adopt this. So we're neutral as to Washington if we don't adopt this.
So what I would like to propose, I'd like to propose that we ask a law clerk, either Talitha, Sandy, do we still have Talitha's time?
It's a bit complicated. We can talk about that later.
Okay, so Sandy and I, between us, will find a law clerk to do this research. And then, so we'll add that to the discussion at the beginning of the next session. Okay. Sandy, will you make a note and add that to the agenda, please?
I have that.
Okay.
Thanks, Valerie.
Because I do think that, particularly since it's a new provision, I think it bears a little bit more investigation. Is everybody okay with that? Kyle, you've been very quiet.
Kathy said she has a law clerk who could help on that as well.
Oh, okay, good.
Yeah, I'm on board with this.
Okay.
So we're going to defer.
We're going to defer making a decision on 706 until we got more info, I think. I mean, I think that's reasonable given the discussion that we've been having, which seems to require more information. Hold on, I'm taping my note to my book. Okay, 707.
So section 707 is entitled disposition of assets and winding up, and the ORS analogs are 63625 and 63674. So subsection A says that in winding up, the company is required to apply its assets to discharge the company's obligations to its creditors, including members that are creditors. This is almost identical to ORS 636251, although I noted in my notes that ORS 636251 includes former members as well who are creditors. So the question is whether we would want to add that particular provision, add that, make that change to subsection A.
I think that makes sense.
So ORS just says includes creditors and members who are creditors and former members who are creditors?
Yes.
Yeah,
well, that's already captured by the idea of credit. Former members who are creditors are just creditors.
That's a good point, actually. So
I'm curious why that additional language is there in the first place. I don't
That's
know
a good
what
question.
it's doing.
Well, yeah, I mean, the change from Oregon law is that Oregon law currently says essentially it puts lower on the tier of payment liabilities for
That's true,
distribution.
actually, that is a.
Oh, sorry. Mhm.
I'm sorry, go ahead.
Well, I was just saying, yeah, do we want to sort of equate liability to members for distributions, throw that in the same pot with all the other payments to creditors, which is what ROLCA does, or do we put payments for distributions to members in the second tier pot, which is what current Oregon law does? And I don't have a strong feeling on that necessarily, but we should.
I have a cross-reference to 404F, which is on page 94, that talks about limitations on distributions to members. And it says, in measuring the effect of a distribution under section 707, the liabilities of a dissolved limited liability company do not include any claim that has been disposed of under 704, 5, or 6. So.
Which section were you quoting?
404F on page 94.
Oh, 405F?
No,
404F.
I think it's 4. Oh, no, you're right. It's 405.
405, okay.
405. I wrote that wrong. Yeah, 405 up on page 94. Yeah, and I think that makes sense, right? Because with the majority of 405, you're talking about distributions of the entity as it's in existence, right? And then the 405F says, okay, we're not going to talk about, we're going to look to those other sections to address what happens when a company is operating in dissolution, winding down. But I just wanted to flag it because we talked about it before.
Going back to Cody's question, I would favor keeping the priority scheme that we have in ORS 63-625 1 and 2, where liabilities for distributions owing to members are a lower priority than other creditors. I think that makes sense. Because this would be a big policy change to put liabilities for unpaid distributions on the same footing as liabilities to third-party creditors. It would be a policy change.
One thought
I would not favor.
One thing I was wondering, Teresa, is this, the ROLCA, the switch from ORS to ROLCA would all else equal disadvantage creditors of the LLC, but it would potentially advantage creditors who have charging orders against LLC members. Is that I'm asking if that's a correct reading of the effect of the change.
I think I would agree with that, Cody.
And for that reason, I was, at least in part, not sure whether I was for or against this. I kind of didn't have a strong feeling about it, because usually I think if you're a creditor of the LLC, I mean, often you're also a creditor of the, I mean, not always, you know, I mean, a tort would probably just be the LLC only, but people who are doing business with these LLCs and members, they may well have, you know, judgment against both the member and the LLC, or it may just be against the member alone.
Yeah, I mean, I read this section not necessarily talking about liabilities for distributions, right? Which is certainly
It's
what
different than a debt.
Yeah, I mean, because you can have members that lend money to the LLCs.
Right. Right.
Right, and that would be put in with all other regular creditors, but money for distributions, I mean, distributions should always come after debts anyway.
Right.
If there's not enough money to pay everybody, distributions should always be in second place.
Right. I mean, that's the That's why I kind of like the ORS language a little bit better in this context, though.
But
Right.
isn't 707B covering the issue of distributions? And
It
notice
does.
the first word of 707B, after.
Mm-hmm.
Right, but I don't think, or I had understood ROLCA to, say that once you've declared a distribution, then the members or their transferees are entitled to that money and become a creditor of the LLC as to that money. And so the distributions would be payable under 707A, sort of first priority.
Yeah, I don't read it like that, because a distribution is distribution from equity. I don't think you think of a customary balance sheet. I don't think it ever becomes something that's booked as a liability of the company.
I think once it's declared though and not paid, it probably does become something that's a liability of the company. So let's say that the company decides on January 1 that it's going to make distributions, but it's going to make those distributions at the end of March. And in the meantime, something drastic happens in February that makes the company insolvent and it decides to dissolve in April. So the promise to make that distribution seems to me that it would fall in an obligation to a creditor that's a member in subparagraph A. Whereas I think that that money would more rightly go to third-party creditors, and that ownership interests and equity, because at the time the person's getting it, there isn't equity anymore.
But
It's not really fair.
Isn't that a contingent obligation? Because remember, there's the statute that says you can't make distributions if it makes the company insolvent.
Well, and also distributions aren't deemed to occur until the end of the tax year either, right? So you would have these intervening events that would have superseded the availability of that money for a distribution.
Well, aren't you looking at that from a tax law perspective? Isn't it from a perspective, the point that the distribution is declared? Isn't it? I mean, I guess you could declare it and say it's payable.
Yeah, Jeff, just to add to your comment, I think the statute states that basically whoever would approve a distribution would have to approve a distribution that would not render the company insolvent immediately after taking effect to that distribution.
So it kind of makes the distribution somewhat contingent on complying with that statute.
Otherwise, they have personal liability.
Right.
But I mean, I guess you might imagine that there might be, enough to pay. Am I correct that we're concerned about the situation where there's enough money to pay non-distribution debts of the company, but maybe not enough to pay all of the distribution debts, right? That's what we're worried about. I mean, maybe at the time you declare that distribution, you've got the assets, but then subsequently, things happen, additional liabilities arise, or value of assets decreases for what could be totally market reasons, right? Where you would still owe that distribution having declared it. And 404D says that if a member or transferee becomes entitled to receive a distribution, the member or transferee has the status of and is entitled to all remedies available to a creditor of the LLC with respect to the distribution. So I really do read then, when I read 707A talking about obligations to creditors, including members that are creditors.
Where were you reading from again?
I was quoting section 404D.
Okay, because I think that's helpful.
And I was reading 404, B, basically, once the company decides to make a distribution, you have a right to that distribution. It may not be recognized for tax purposes until later, but I think once that distribution is declared, then everyone has the right to it. And therefore they are a creditor of the LLC as to that distribution. I could be misreading things, but that's how I understand it.
Yeah, Cody, that 405 prevents a company LLC from making a distribution if after the distribution the company would not be able to pay its debts, or it would be insolvent. So
Right, but
it's not a matter of that determination.
I'm quoting page 91, 404D.
No, I know, but 405 is a limitation on 404.
Right, but when does that limitation apply? At the time that the company decided to make the distribution, or the time that it actually sends the money out? Because the problem that you have is, I mean, imagine the business that in January of this year said, we want to make a distribution.
It's
And,
pretty
you know,
clear that it's, an LLC may not make a distribution. It has nothing to do with the approval of it.
So it's a date of payment, you're saying, Cliff.
Yeah, I think that's correct. In 405A, the second line of that, if after the distribution. So I don't think it's the declaration. It's the act of making the distribution. If that drives the company into insolvency, then that's what seems to trigger 405.
So if I'm understanding you correctly, then you're saying that there never would be a situation where distributions would be payable under 707A. There just never would be a situation where they're payable under that. They're always going to, distribution will always be a second tier thing. Or if you know, I mean, is that right? That if there theoretically were to be a distribution that was under first tier priority, it would be an invalid, illegal distribution anyway?
That's, I think I read 707A to talk about that members that are creditors language talk about like bona fide debt, where a member has lent
a loan,
right? Yeah. Which certainly happens. That you have a member making a capital contribution, that's equity, and a member making a loan, that's debt, and they're booked distinctly.
Michael, in light of what you just say, there's a definition for distribution on page 8. And it says distribution means a transfer of money or other property from a limited liability company to a person on account of a transferable interest or in the person's capacity as a member.
Right. And
then it goes on, the term includes and talks about different things like a redemption or the liquidation of an interest and stuff. But it doesn't answer the question of whether you become a creditor once your distribution is declared, but it does make it clear it's not a debt. It's not a creditor situation. It's on account of a transferable interest, essentially, in the LLC, or as the person's member.
Right. I mean, I don't think we're disagreeing, right? Because you can have situations where you're making your payments on account of debt and then other payments on account of their ownership interest in the entity.
Right.
So can I ask a question? What do you do? What is, Cliff or Michael, what is your view what if there is a distribution declared but not yet paid, and then subsequently the LLC goes into distribution? What language in 707 captures payment of that declared but not made distribution? Or is it your position that declared but unpaid distribution just is void at that point?
Well, my position is that if they made the distribution that would then be illegal, then whoever authorized that distribution could be held personally liable.
Yeah, I agree.
Right. But how does that, but I'm just asking the question, like, not about a made distribution, but one that has not yet been, the money has not been paid out yet.
So it's been declared, you're saying, Cody, but not yet paid.
That's my question. What do you do with that where a distribution?
I don't believe that the company can legally make that distribution.
Yeah, I agree.
Even if it's been authorized. Because
it's almost like, are we talking accrual basis or cash basis? And it seems like, a declaration, it's accrual, but I think when we look at these distribution sections, the sections that Jeff just pointed out, and then back over to 707, I think the act of moving assets out of the company is really what's in play here, really on a cash basis, the disposition of assets. And again, I don't think a declared distribution is going to come under 707A. I think it'd be tortured logic to get there myself.
Well, I agree, Michael. And I think too that, even under an accrual basis, there are these other things that prevent them having the fixed and determinable right to that distribution, right? And so you wouldn't necessarily be able to accrue it anyhow until it's actually.
Right.
Well, yeah, and it's been a couple years since my public accounting days, but I don't. Grant Thornton treated me well. It was good. But yeah, I mean, it's not you wouldn't ever accrue a liability for declared dividends on your balance sheet. You would include it as in the footnotes that the company had declares it, subsequent event.
Yeah.
You wouldn't record liability.
So then if we think that a declared distribution that's not been made is never a creditor issue, then I'm wondering if we ought to put something in the comments to explain why we don't think this would be a change from Oregon law.
Yeah,
I agree with that completely. So I mean, I just to
Yeah. I'm fine with that, and that's how I read it myself.
Yeah.
So there is no such thing as a
doesn't really present a substantive change.
So
I agree as
there is
well.
no such thing
Go
as
back
a
around to
distribution.
6365.
So Cody wanted to say something.
Sorry, I just wanted to clarify. So there is no such thing as a distribution that gets made during winding up. It just does not exist.
I can't hear you.
I think your audio might have switched to a different channel or something.
Can you hear me now?
It's very faint.
Can you hear me?
Cody, I think to answer your question, it's just not an operating distribution. It would be a liquidating distribution.
Right.
And I'm sorry, folks, I'm gonna have to jump off for another meeting.
Okay.
Fun
Thank you
discussion.
for.
Thanks all.
Thanks, Cliff.
I agree with the statement in the notes, but do we want to be maybe stronger and just simply say that intent that words obligations to creditors do not include distributions, or at least declared and not paid distributions?
I mean, it's different than like a corporate sense though, right?
I think Chef's idea is a good one, though. I would agree with that.
I mean, let's just state it that the intent here is this 707A just does not apply to distributions.
Yeah.
Because to point the ORS, to be consistent with the ORS, go to the ORS and interpret it. Let's make the affirmative statement that without changing the 707A language, that our intent is this does not apply to member distributions.
So Jeff, you're saying put that in the notes?
Yeah,
in the
I mean,
comments.
it's either that or put it in directly into a 707A, but I think we probably prefer not to monkey with the language and just state our clear intent in the notes.
Yeah, I agree. I wouldn't want to monkey with the language because I think we're talking about a narrow set of circumstances here where this situation would arise.
Yes, I agree.
I also think when you look at 707B, it kind of addresses the issue to some degree as well, because it talks about distributions there. So
you might even, to the note on A, say, member 707A doesn't apply to member distributions, look to B.
Yeah.
So I get to the same place in terms of what the note actually says. I agree that we should add a note, and I agree with the result that everybody here is discussing, but I'm not sure I agree on the analysis to how to get there. And I'm stuck on whoever cited 404D, where it talks about a member who's entitled to receive a distribution being a creditor. The way I get to the result, it may well be that a distribution that has been declared would be an obligation to a creditor under 707A. I just think the company can't make it.
But aren't you kind of, let's talk about the spirit of it. I mean, the idea is, and this kind of comes out of the bankruptcy world where Teresa is, you have secured first, preferred, and unsecured. And by analogy, this is a return on capital. That's what a distribution is, right? Essentially a return on capital. And isn't the spirit that the creditors get paid first, and then return on capital, if there's anything left, comes second? And it feels like, we're potentially, with the argument that you're making, James, is you're elevating a distribution to a creditor level. And it just feels like
I'm not doing it. I think 404D.
No, I don't think so, because I think 405F comes into play, which is the limitation taking distributions in the ordinary course out of the discussion of, liquidating distributions.
Yeah, because 404 distributions before dissolution is the zone in which 404 exists.
Yeah, and then 405F is like all the limitation provisions. And, you know, it makes sense to me that what Jeff is saying, you know, we have our distributions during the lifetime of the entity, but that as soon as it enters dissolution, you have to think about it differently.
You have to deal with the creditors first, and you give priority to the creditors.
Yep. And then section 707B basically just says distributions and orders subject to charging orders, you know, and I think that the order of this makes sense. David, did you have additional thoughts about it?
No, although it's not identical to 63, 625, 2 and 3. And the ORS talks about allow surplus to be distributed to first to members owed interim distributions, which I think is a concept not really under ROLCA, and then also for distributions owed to assignees. I don't know that we need to carve out those in adopting this, but Oregon, for whatever reason, does carve them out.
Does anybody feel strongly about adopting the Oregon language? I don't, so. Okay, so we will just go with ROLCA because that's our general policy decision. And then C basically says if there's not enough money, surplus is then distributed, you know, in proportion to the members as far as their transferable interest with what's left. Which makes sense, right?
Yes.
Just split up what's left. And you can't pay your money in chicken. You can't pay your distributions in chickens is basically D.
There's no ORS analog to that, so.
Although this is a zone that operating agreements typically would deal with.
Right.
They would,
yeah. Distributions, yeah.
Yeah.
So.
I was going to say, is this one of those provisions that can be varied? Because I can imagine an LLC that might own 3 pieces of land and decide that once they've paid all the creditors, they're just going to give one piece of land to each of the 3 members. And they could all agree in advance that they wanted to do that.
Comments say as between the members, you can vary it. You can't vary it as to
creditors.
Okay, that makes sense. Thank you.
Yeah.
It does say that these are default rules in the commentary.
So if you want to get paid out in chickens, you totally can.
You may prefer chickens.
You may prefer chickens. Okay, anything else on 707? Cody.
Valerie, just a time check. We're 8 minutes till.
I know.
Okay.
Can you hear me?
Almost, but yeah.
We can hear you.
Check down, check chat.
That was better.
Oh, should we insert 63,674 as ROLCA deposit with Department of State lands? Yeah, probably. That makes sense because that's the catch-all, right?
Yeah, that's a good point. Actually, I have that in my
Yeah.
notes.
No, thank you, Cody.
We do need to add that. That is unique to Oregon.
And as a note, everybody's checked their name in the unclaimed property logs. If you haven't, please do, because there may be money sitting out there for you. And the Department of State Lands manages that. Okay. Anything else on 707? Hearing none. I think this is a good place to stop, given that we've only got a couple of minutes left. We have a meeting set on December 9th.
Yep.
I would like us to set a January meeting because we don't have one set yet.
Yep.
What do people's schedules look like at the beginning of January? So we could do the 6th. What does the 6th look like for people? 6th or the 7th are both good for me. Any preference either way?
6.
I prefer the 6th.
Kyle says 6th.
All right, let's go with that. Let's do the 6th.
Okay, I'll send out the info.
Okay.
So the dismal 2020 will be over by then.
Oh, let's hope and pray. I was
Okay.
thinking, Teresa, when you were saying that what happens is, 2020 happens again. I'm like, oh God, no.
And then
So-
just Valerie, for planning,
No, we don't want that.
Right?
Valerie, for planning purposes, Cody in the chat, should we plan on doing Article 8 in December, or do we want to wait?
Well, so right now we've got 708 and 709 and 710.
So 708, I think we'll have some discussion.
Yeah.
709
And I
and
think
710, I don't think are particularly controversial.
no, although 710 is new.
Right.
I mean, I agree. I don't think it's very controversial. So I think we will wrap up. Although we have, so Cody, you're doing 8. Who's doing 8? Okay. I think we'll at least get through 801 and possibly start 802 next time. We do have the discussion though at the beginning of the session about Jeff's homework and a couple other items that we flagged today. So
Yeah.
we'll do that first, and then we'll move into the 3 remaining sections of Article 7. So we probably won't get too far into 8, is what I'm saying.
Yeah.
Okay, so we should plan on part 8 in January.
Well, we might get to it in
We could
December.
get to
We
it.
might get into like 801 in December, just depending on how, I mean, I agree with David that, we're gonna have some discussion on 708. Which is the administrative dissolution provisions. And, so we'll definitely want Ruth and Jamie to weigh in on those. So,
Yep. Well, we'll be prepared to go on 8.
okay. Yeah, at least the first section or 2. I don't think we'll get too much past that. And then we'll meet again on Wednesday, January 6th, 9 a.m. to noon again.
Okay. Yep. I'll send out a invite that has a clear that will not have a password this time.
I mean, I don't care if there's a password as long as
No,
that's what it is.
there actually wasn't a pass. It's a long story. Everyone got in. It's all good.
All right. Okay. Thank you all so much. I think this was a really good discussion. I really appreciate Cody again for pulling together that memo on the discussion items. So on charging orders, and I will look forward to seeing you next month. Have a wonderful Thanksgiving. Be safe.
Thank you, everybody.
Thanks
Bye-bye.
all.
Bye.
Thanks.
Bye.